morning, everyone. Thank you for joining us here today. This morning's session, we're going to be discussing broker liability, and I just want to preface this session by saying this is not a session on how to sue your broker. We have many brokers in the room. Brokers are our friends. Instead, this session is going to objectively discuss the real potential exposures that brokers face, how courts, particularly in New Jersey, consider those exposures, and hopefully for our broker friends, how to avoid liability. To our policyholders in the room, we intend to cover what expectations you should have when dealing with your broker, some tips to ensure, hopefully, clear, effective communication, which will hopefully avoid issues down the line. So why does broker liability matter? Seems fairly simple and straightforward, but we'll go ahead and lay the foundation for our discussion this morning. Unfortunately, a very common situation that policyholders encounter is they suffer a loss, they turn to their insurance company, they thought they had coverage, but they don't. And so that gap of having an expectation of coverage or thinking that you have coverage and you don't, that gap is where broker liability lives. And so oftentimes policyholders will turn to their brokers and the question arises, well, can they? And in New Jersey, that's a very generally, that's a very fact-specific question. And specifically in New Jersey, the answer starts with the foundational principle, which we'll get into more detail on later, that insurance brokers must exercise reasonable skill, care, and diligence in procuring coverage. So with that said, I'll turn it over to you, Adam, to discuss the role of an insurance broker, and hopefully you can tell us a bit more about your personal experience as well.
Yeah, sure. This is a very self-explanatory slide, but the role of the broker is basically to both understand the insurance client's needs and also understand the insurance market. And then, the most important of these, obtain the coverage the client requests. And I just want to emphasize the client requests because that's going to be something we're going to talk about a little more in depth as we move forward. As Christina mentioned, it's exercising skill and diligence, ordinary reasonable skill and diligence in obtaining insurance coverage.
John.
Good morning. I'm going to talk about the expectations of the policyholder. The policyholder is often not an expert and relies on its insurance broker when looking for insurance. The policyholder expects that its insurance broker will obtain the coverage that the policyholder requests. The policyholder expects its broker to exercise skill, diligence, including keeping the policyholder informed. The policyholder expects its insurance broker to advise it on the availability of coverage that meets the policyholder's needs. It's a lot of times, there are companies that don't have internal risk management folks who help out with procuring insurance, so they're going to their broker as outside help to assist them with procuring the coverage that they need. A lot of times, clients are unsophisticated and they don't even know what insurance they may need. And so the broker is there to help them with that, as well as to explore the market to match up what is available in the market with that policyholder's needs.
So we touched on this a bit already. And in New Jersey, brokers owe a duty to exercise reasonable skill, care, and diligence, and are expected to possess reasonable knowledge of the types of policies that are available, their different terms, and the coverage generally. If, however, a broker fails to procure that requested coverage, or the policy is void or materially deficient, or does not provide the coverage the broker undertook to supply, the broker becomes liable. And this is established in Ryder versus Lynch, which is the seminal case in New Jersey on broker liability. And so ultimately, a broker who undertakes to procure insurance and fails to do so with reasonable care, or alternatively, fails to notify their client, can be liable for the resulting uninsured loss. So what does that mean practically? It means that the broker becomes a stand-in for the missing, unavailable insurance. And when dealing with policies in the multi-million-dollar, limits, that can be fairly substantial. So one of the key takeaways from Rider is that a broker must either get the requested coverage or clearly inform the client that they were unable to do so. And so silence can oftentimes be the issue, and be what gives rise to broker liability in general. So we hope that one of the key takeaways from this morning's session is that communication between a broker and a policyholder really is key. And it's also very important to remember that the duties established in Rider are the floor, not the ceiling. And so there are cases that follow, which we'll touch on later, that establish different standards, like, for example, the special relationship doctrine, which John will discuss shortly. And with that, we thought we would go through some scenarios and take an informal poll of the room, just by a show of hands, on our thoughts generally regarding some scenarios in broker liability.
So I'll read the scenario. Everyone can see it up on the board as well. But policyholder purchases condominium. Prior to closing on the condominium, policyholder contacts the insurance broker to request coverage for the new condominium. Insurance broker had been providing other coverages to policyholder for many years. Policyholder requests the coverage that would cover any losses to the condominium. Policyholder signs the insurance application and purchases coverage for the condominium. Subsequently, a fire damages the condominium. Due to a limitation in the policy, the policyholder made repairs out of pocket. Is the broker liable? Is the broker not liable? What do you folks think?
Let's get a show of hands for broker is liable. I'm going to show of hands for not liable. I didn't do a formal count, but I think not liable won the room. John?
That's right, and you're correct. So no general duty to advise under these circumstances, and part of the issue was that the policyholder didn't provide accurate information to the broker. So I think that this case highlights the importance on the policyholder side to be as accurate as possible when you're communicating with your insurance broker so that they can accurately go to the market and get the insurance coverage that policyholder needs.
Right.
Yeah, so are we talking about Aiden for 1 second?
Yeah, go for it.
Yeah, so this case that John was citing is Aiden versus Forge, a 2001 decision by the New Jersey Supreme Court. One of the interesting things that I noticed preparing for the session is that New Jersey, as a jurisdiction, imposes the broadest duties on insurance brokers in terms of liability. All other jurisdictions, and I'm speaking specifically about New York, Pennsylvania, Maryland, Delaware, and DC, are not as, they look at broker liability on a more narrow basis than New Jersey. A couple of things here. This case, Aiden, first of all, in New Jersey, no comparative negligence in insurance broker malpractice cases. That's only in New Jersey. They don't allow comparative negligence for not reading a policy by an insured. So, in New Jersey, you can't say, the insured failed to read the policy, I have a defense to that. No, it's not going to work here. But it's an outlier. In the other states, that's not the case. In all other jurisdictions, they follow request-based model where brokers have to obtain generally what an insured requests, but they don't have generally a duty to advise, which we're going to talk about a little more in terms of the special relationships and how New Jersey courts can sometimes add to the obligations of an insured to advise based on conduct in the past.
So with that, Adam, you want to take us
yes,
to
so we're going to talk about one other scenario. The policyholder obtains a med mal policy under an occurrence form. The policy gets canceled. The prior policy was canceled due to a failure to pay premiums. The policyholder discusses replacement coverage with his insurance broker. The policyholder completes the application, but he doesn't answer certain questions, including what's the requested effective date of coverage, what was his insurance history for the previous 3 years, and whether the current coverage was claims made or occurrence. The policyholder obtains a replacement policy on a claims made form. Subsequently, the policyholder gets sued for malpractice. The coverage gets denied by the insurance company because the incident occurred before the retroactive date. So the question here again is, do you think the broker's liable or not liable? Show of hands for liable. Okay, show of hands for broker not liable. Well, it's close, but the people who said not liable are correct. This is the case of President versus Jenkins, which is a 2004 New Jersey Supreme Court decision, which holds that insurance brokers don't owe a duty to advise about retroactive dates in insurance policies, and also the insurance broker's actions, or where the insurance broker's actions were based on information that was provided is consistent with custom and practice. The key takeaway from the case is that policyholders have an obligation to provide accurate information to their brokers, and the broker's duties are not unlimited. Again, with respect to brokers in New Jersey, their duties are limited to exercising good faith and reasonable skill and care, but they don't have to guarantee an outcome as to coverage. And in the case of Jenkins, the agent didn't breach his duty of care because, number one, the insured misrepresented his history and didn't disclose prior policy cancellations. Number two, the insured ignored the agent's advice to pay his outstanding premiums to avoid cancellation. Number three, he signed an acknowledgement form that Zurich, who was the insurer there, that their policy was claims made, and by signing that acknowledgement, he also said he understood that incidents before retro date weren't covered, and also there was no expert testimony used to establish that he had somehow breached the ordinary standard of care. So again, I think the most important takeaway from this case is just to remember that, we all have obligations in this, insureds, brokers, insurance companies, and, we have to make sure that our communications are clear and effective to obtain coverage. So.
All right, I'm going to turn it over to John for the special relationship doctrine, and also please feel free to add anything with respect to Aiden,
Sure.
President, Ryder. I know you've been in the trenches on this stuff.
Sure. So just going back to the first scenario, I actually made a mistake, and I was thinking of a different case. Aiden v. Force, they actually did hold the broker liable. And one of the key issues in that case was the signing of the insurance application. And a lot of times what brokers will argue in the context of litigation is that by signing the insurance application or the quote or whatever it may be that they signed, that the policyholder understood the contents of what was signed. And so Aiden stands for the proposition that there's no comparative negligence defense in the context of a broker malpractice case under New Jersey law. And that's very important because there are things that come up in the context of a relationship between a broker and a policyholder where a lot of times they're going to be pointing the finger at one another due to lack of communication, lack of records, informalities that create that void where they then can point the finger at one another. And so Aiden stands for the proposition that you can't point the finger at the policyholder as the broker to absolve yourself from liability on things like signing the insurance application or pointing to their level of sophistication, the policyholder's level of sophistication. The broker is a fiduciary under New Jersey law. Real quick, I had a jury trial in March, started on March 2nd, thought we were going to be done March 6th. It actually went till March 27th, which was crazy. But, this comparative negligence issue came up a lot. And in fact, the broker was asked at a deposition, "Are you a fiduciary?" And he answered, "I don't think so." And so, we heard all about his background education as to how he became a broker. And he explained that in his education, he never heard that term, and then did some investigation after the deposition, and then understood at the time of trial that he was a fiduciary. So I think it's important, for brokers to understand that they are fiduciaries under the law. And so there's a heightened level of care, as a broker to a policyholder. Now, that doesn't mean that in that context, the duties are unlimited, of course, but it's an important role that the broker plays for the policyholder. Now, this special relationship is more of the same in terms of the heightened standard, but a lot of it depends on the course of conduct of the parties. So, we have case law starting in 1964 with Ryder, which has developed since then over the last 50, 60, 70 years. And the special relationship comes into play where you have the baseline duties of a broker, but based on the course of conduct in a given situation, those duties are heightened because of instances where the broker takes on additional responsibilities that are not ordinarily duties that brokers would take on. And so a lot of times in broker malpractice cases, the broker will say, "I didn't owe the policyholder a duty to do X, Y, or Z." And they'll cite case law in New Jersey as saying, "These are our duties and they're limited as such." Well, then the policyholder will argue, "Well, wait a minute, let's look at the course of conduct here. The broker took on these responsibilities, we relied on them, and therefore this special relationship applies, and thus the broker did owe us this particular duty, whatever it may be, that is outside the typical duties a broker would owe." A lot of times it depends on the length of the relationship and the extent to which they are assisting with the procurement of coverage. I mean, a lot of times it's not just the procurement of coverage that brokers do for policyholders. It's a risk assessment. It's providing scenarios. And a lot of times it just depends on the course of conduct of the parties as to whether a special relationship exists.
Yeah, I'd just like to also add, John, that, again, the special relationships, and I think the takeaway for any brokers in the room right now is to realize that, again, in New Jersey, if you're doing business here, it's easiest to establish this special relationship obligation in New Jersey. It's harder in other places. Like, for example, in contrast to New York, there is no general duty on an insurance broker to advise a client, and a special relationship exists only where there's either been A, compensation given specifically for advice, B, a history of reliance on the part of the client to rely on the broker's knowledge for certain things, or C, the broker actually holds itself out to be a specialist. Now, I think, at least the brokers I work for, we hold ourselves out to be specialists. That's easy, but I also think that you do need to, every case is fact specific. You need to look at the types of clients involved. Are they personal? Are they commercial? You need to look at the brokers and agents involved. Are they, small, large, etc., and what they're holding themselves out to be. But again, New Jersey, be very careful and be very careful the way you communicate and what you put in your file, because again, courts in New Jersey hold brokers do owe a fiduciary-like duty to their clients to exercise good faith, skill, and diligence, and the conduct that you engage in may also impose that heightened special relationship to the client.
Actually, I'm going to leave it with you.
Okay.
Going backwards.
So where brokers can get into trouble. Yeah, and again, failure to procure coverage, that's really critical. And I would say to insurers, you should be very careful to make sure the broker knows what you want, what coverage you're asking for, what specifically you're looking for. And if you do that and you document that, then the broker has the obligation to get you that coverage or advise you, I couldn't and here's why. But if you just leave it up to the broker, say, just get me what I need, or, that could be a problem. So be very accurate in what you're looking to procure. Misrepresenting coverage. If a broker turns around and tells a client, I got you X, but really it only covered Y, that's a problem. Not understanding the policyholder's risk. So again, a broker needs to be very careful to make sure they speak clearly and interview their client, understand what type of risks they have. And then documentation failures, lack of written records, ambiguous communications. All those things are places brokers can get into trouble. And how to avoid it?
Correct.
All right. Aiden v. Forsch actually expressly provides an instruction to both policyholders and brokers, and it's so important. And it says a lot of these issues can be avoided by clear communication. And that goes on both sides. It's, confirming all coverage requests in writing. A lot of times there's no written record of what was actually requested from the policyholder. You could find yourself in a situation where your longtime broker, is a friend now, and you're talking on the phone a lot of times, and you end up in a situation where you suffer a catastrophic loss, and because of the informality of phone calls between you and your broker, you now have no written record as to what you specifically requested. It's your word versus his, and that a lot of times, if you make it that far, will be decided by a jury. Avoid vague terms like full coverage. I think as policyholders, all policyholders want full coverage. I don't think I've met a policyholder who doesn't want full coverage, but there are limitations in the policy and things that you have to be aware of, and that's what the broker's there for, to review the policy with the policyholder, inform them of those limitations, and so that everybody understands and is on the same page. Keep records. I touched on that. Don't act like a lawyer, even if you are one. Again, I think especially lawyers, my goodness. The broker is the specialist, and you can consult with the broker for sure, but, I think it's important to talk with the broker and hear the broker out and not just dismiss what the broker is saying in terms of things they're privy to that the policyholder is not, such as going out to the marketplace. They're the ones who are going to be familiar with the market access. They're going to know who is available to provide the coverage that you need and who is not. Be an advocate, but don't opine on legal issues. I think, you can always get into trouble that way. And know when to consult coverage counsel. There are any number of scenarios, and there are no shortage of attorneys available when you need them.
So just to end our session this morning with some practical guidance for policyholders, understand your needs as best you can. No one knows your business like you do. So the more effectively you can identify your needs, the more effectively you can communicate those needs to your broker. Reassess your risks annually, and perhaps even more than annually, and be aware of changes in business or potential new exposures. Business landscapes change all the time. So if you take on a new risk, if you open a new department, or anything that happens within your business that could potentially change your insurance needs, you should be flagging those for your broker. Even things like the rise in cybercrime, the very fast change in AI, you should discuss those things with your broker to see what coverage can potentially be available for you. We already talked about making specific written requests for coverage. John touched on that. Adam touched on that. Document everything and ask the right questions, whether they're specific coverage questions or trying to see if your broker can help you to identify the gaps in coverage. Again, communication is key. And so I think with that, our time is just about up.